Your Honor, we were before the court 3 months ago on this matter for sentencing. At that time, the defendant tried to persuade the court that she was genuinely remorseful, that she recognized and understood her need for treatment, and that she could comply with the treatment directions that the court imposed. Essentially, she said that she was amenable for treatment and that she was deserving of treatment. At that time, the court specifically warned Ms. LeTourneau, and I'll quote from Your Honor's sentence, "If you fail to comply with any conditions, either of this court, imposed by the Department of Corrections, or any of your treatment providers, it will result in immediate revocation of the suspended sentence, and you will be committed to the Department of Corrections for 89 months. We're here today, this morning, Your Honor, to present evidence that in the one short month that Ms. LeTourneau has been out of confinement, that she demonstrates that she is not safe to be at large in the community and that she is not an appropriate candidate for community-based treatment. We are urging the court this morning to revoke the 89-month suspended sentence. As the court is aware, Ms. LeTourneau was found in the company of the now 14-year-old victim who was the victim in the underlying charge for this court, that she was found with him in the early morning hours of February 3rd. As a result of that, her community corrections officer for the Department of Corrections has notified the court of 2 violations. First, that her contact with the victim is in direct violation of Your Honor's judgment and sentence. And secondly, that Ms. LeTourneau has been terminated from her sexual deviancy treatment program that was being conducted by Dr. Terry Copeland. It is my understanding that these allegations are being admitted.
That is correct, Your Honor, although it's semantics, but the violation said that she failed to make reasonable progress and to successfully complete a program. Her progress that was made was as predicted. Dr. Copeland did tell the court in writing that it would be difficult at the start and that was not uncommon, and he predicted after a few months Ms. LeTourneau, like other patients, would settle down. The wording as enunciated by Ms. Johnson is correct, and we admit to that, and the semantical difference was the written wording of CCO, Mr. Gelke.
Ms. Johnson.
Thank you, Your Honor. The state does wish to present testimony to this court this morning that should demonstrate to the court the full extent of the defendant's violation, what we believe to be an egregious violation of the court's order. In support of our motion for revocation of the suspended sentence, I trust the court has received the report of Dr. Copeland, dated February 3rd of 1998, which does terminate Ms. LeTourneau from his treatment program. Am I correct? Dr. Copeland indicates that because of the seriousness of the violation involving being in contact with the victim, that he is no longer willing to work with her, and she is immediately terminated from the treatment program. In addition, he also indicates that the prior month of sessions with Ms. LeTourneau has provided nothing but contentious sessions in which she has repeatedly argued with his treatment program, tried to define his role as a treatment provider, and he defines those as having all been contentious. Officer, will you state your full name and spell your last name for the record, please?
Officer Todd Charles Harris, and that's Harris.
And could you give us a business address and zip code for the clerk?
That'd be 610 3rd Avenue, Seattle, Washington, 98104.
Officer Harris, were you on duty on the early morning hours of February 3rd, 1998?
Yes, I was.
And what is it that you recall happening that night that brings you to court here today?
At about 2:24 in the morning, I was on patrol when I saw a suspicious vehicle parked on the side of the road with its parking lights on. I decided to go ahead and investigate it. As I passed the vehicle, I ran the vehicle's registration on my MDT. I could tell there was 2 individuals inside the car.
How could you tell that?
Well, I could see that the driver was with their back to the driver's side door with their head pressed actually against the window. So I could tell that it was a blonde-haired driver. And on the other side, she was facing a position that would be very much show that she was talking to somebody who was in a passenger seat, the way she was facing. The passenger seat was in a position that it was laid down where I could not see the headrest. But I could, just by the positioning of the driver, and that I concluded there was probably more than likely two people inside the car.
And so what did you do at that point?
Well, I ran the registration of the vehicle. It took a while to come back to who the registered owner was, so I was several blocks away by the time that came back. When I saw who the vehicle came back to, I went ahead and decided to go investigate it a little bit further.
Who did the registration come back to?
Mary LeTourneau.
And was that a name you were familiar with?
Yes, it was.
What did you do then?
At that time, when I pulled up behind the vehicle, I stopped and turned on my spotlight. As soon as the spotlight came on, Mary was outside of the car and coming back towards my patrol car. At that time, I went ahead and got out of my car and contacted her and asked her if everything was okay. She stated yes. I asked if anybody else was inside the car with her. She said no, and I asked her again, and she again said no. And the driver's side door was open, so I went ahead, walked forward, and looked inside the car, and there was a young man inside the car.
Did you ask her for any identification at that point in time when you went and approached the car?
Well, I went ahead and had her sit back in the car as soon as I found out there was another person
Mrs.
inside
Ingalls
the
at the
car.
courthouse.
Then
Can you
I
guys
did
hear
ask
me?
for identification.
For a second, I thought you had the pager.
A picture ID on her.
At any point, did she give you a name?
She did, in fact. She gave me a name of Terry Schmitz.
And at what point did she give you that name?
When I asked her after she had stated that she didn't have a driver's license, she said her name was Terry Schmitz.
And what did you do in response to that?
I went ahead and wrote it down, got a date of birth from her, and verified the spelling on the name.
What did you do then, officer?
I then asked the young man sitting in the passenger seat what his name was, and he gave me a name, which was incorrect as well. Both times, there was great hesitation on both parties in giving the names.
What did you do then?
I then asked if she had a registration for the car that would show who the owner was. She had stated the car belonged to her father. It was registered to her father. She was unable to produce any type of a registration or insurance card. That time I went back to my vehicle and called for a backup, knowing that the information was false on both accounts.
And did you talk to either of the parties additionally?
I'm not understanding.
Did you
the
talk
question.
to either of the individuals in the car after that?
Yes, after we pulled both of them out of the car, I took Mary back to my patrol car where she finally told me who she was, and that the boy who was in the car with her was in fact the father of her baby.
And when she indicated who she was, who did she identify herself as?
She had told me that she was Mary LeTourneau.
And did she give you any explanation of the events of the evening?
She told me that they'd only been home just a few minutes, and previous to that, she told me, when I first contacted her, she told me she was sleeping in the car. Then she later told me she was only home for 6 minutes. So she said she came home from a movie, that the young man was there when she arrived home, and that they'd only been in the car for approximately 6 minutes talking.
Was there anything you observed about the vehicle that would indicate something inconsistent with the story she was giving you?
The vehicle's registration, she said it was registered to her father. It was in fact registered to her, and I knew that previous to contacting her who it was registered to. The condition of the vehicle, as far as her saying they were only there for 6 minutes, there's a great amount of condensation buildup on the inside as well as on the hood of the car, showing that it had been sitting there for a while.
And did you have any other further contact with the young boy?
No, I didn't.
And you say you called for backup then?
Yes.
I have no further questions, officer.
Do you wish to inquire, Mr. Craig?
Questions, Your Honor. Thank you, officer.
Thank you, officer. Ma'am, what do you- Good morning, sir. Do you affirm the testimony you're about to give will be the whole truth in this case?
I do.
Thank you, sir. Please be seated.
Good morning, Detective Bean.
Good morning.
Please state your full name and spell your last name for the record, please.
My name is Dane A. Bean. Last name is spelled B-E-A-N.
And if you could give us a business address and zip code, please.
That's with the Seattle Police Department, 610 3rd Avenue, Seattle 98104.
Detective Bean, have you been involved in the investigation since February 3rd involving the detention of Mary LeTourneau?
Yes, I have.
And are you essentially the case detective on this case?
Yes, I am.
Could you explain to us your involvement in this particular case when you first got involved?
Yes. I'm assigned to the Special Assault Unit, and we were called out to the case after 3 o'clock that morning. Initially, briefly met with the officers at the South Precinct, and then we came downtown with Miss LeTourneau and the boy. My involvement began with interviewing the young man at our office to get an idea of what happened.
And was he willing to speak with you?
He was. Initially, he asked me if he could call his mother and told me that the family had an attorney that was representing them, and he wanted to talk to each of them. He gave me the home phone number, and we did call, and I spoke briefly with his mother and asked her to have their attorney call, which did later happen. And then I proceeded to interview the young man.
And what did he tell you?
He was somewhat hesitant to talk. He told me that he didn't know at this point who he could trust, that he felt the things that he said to me would be used against Mary, that he identified her as Mary. But then we did, after he talked with his attorney, we did discuss the case. I asked him how they had come into contact the previous evening. He told me that he had wanted to talk to her and that he remembered a pager number that he had used earlier in their relationship. And so he was in the White Center, Roxbury area of Seattle, and he called the pager number from a payphone. She called back a few minutes later. He said that they talked for, he thought, 30 to 45 minutes on the phone and decided to go to a movie. This would have been, by his estimation, between 7 and 8 p.m. On Monday night, the 2nd. He then told me that he took a cab and a bus up to the north end of Seattle, to the Oak Tree Plaza. I questioned him a little bit about the cab. He told me at that point, he said he didn't actually take a cab, that she'd come over and picked him up in her car. I asked him what kind of car she was driving. He told me it was a small German-made car, and that they then went up to the Oak Tree Plaza. He described that they bought some food at Larry's Market, that they then went to a movie at the Oak Tree Cinema. Asked him what movie. He described the movie to me, gave me the starting time of the movie, which we later verified as well. He said that following the movie, he thought they got out around midnight. They returned to her car and drove down and parked at the spot where Officer Harris contacted them later that morning. He felt that they were in the car an hour and a half or so. I asked him what had gone on in the car. Had there been any contact? He told me that they had not had sex that night, that there had been no sexual contact. He described to me, however, that there was, they held hands. He held her. They kissed frequently in the car. I asked him if there had been any other types of contact. He told me that he had rubbed her leg. I asked him what he meant by that, and he indicated that he had been rubbing her right thigh, the top of her thigh. Again, I questioned him fairly closely if there had been any fondling or sexualized touching, and he said no, that there had not been. I asked him if he had any items in the car, and he described some clothing articles, some property, cigarettes, a pager, and some items like that that were his that he'd like to get out of the car if possible. And I later spoke with his attorney and advised him that if we did search the car that we would try and locate those items. I later then met with his attorney. He came in that morning and took the boy home.
Did he talk to you about any of the clothing he was wearing? Did he identify any of the clothing he was wearing as belonging to Mary?
Yes, he had on a black parka coat that he said was Mary's, and we retained that when he left the office.
And going back to, you said that he had recalled a pager number that he had used in the past.
Yes.
And in the past to you, what was the context that you understood this to be?
I asked him if, was this prior to her arrest or going to jail? And he said yes, that the number had been used prior to that time.
And did he specifically give you that pager number that he used?
Yes, he gave me 2 pager numbers, one that he said was his personal pager and one that he used to contact Miss LeTourneau that night.
You've talked about items of clothing in the car. Did you subsequently take a look at the car?
Yes, I did. It had been impounded by the officers following her arrest. And I assisted the Department of Corrections with the search of the vehicle later that day.
Did you also photograph the car, Detective?
I did.
I'm going to hand you what's been marked as State Exhibit 1 for identification. If you could look inside the contents of that envelope, Detective, and I'll ask you whether you recognize what's contained in the envelope.
Yes, I do.
I would offer State's Exhibit 1 so that Detective Bean can explain to the court what he took
Your Honor,
photographs
I believe
of.
I've reviewed them. If I could just glance at those briefly and make sure that those are the ones I've seen. No objection, Your Honor.
One is admitted.
You can take those in whatever order you wish, Detective. What was the first thing that you noticed about the car?
The car had it's a small Volkswagen. I believe it's a Fox model. It's a 2-door car. Car had a lot of property in it. The back seat was full of clothing articles, boxes. There was a small, almost like a mini safe, small, strong box. The floor seat and the passenger side in the front was stacked up with sacks of clothing, food, other objects and items.
Do any of those photographs reflect that you could show to the court?
Yes, they do. Would you like me just to hand these up to you? Would it be all right if I stood here? Okay. These first few are views of the exterior of the car. It's in our processing room. It belongs to the apartment. You can see that there is a substantial amount of property stacked up. This is a view of the back seat area. There's some boxes, a gas can. This is from the driver's side, looking in with the doors open. This view is the front passenger seat in front of the floor in front of that seat. This is how we observed it first. Then these next 2 photographs are kind of in layers of property. We've removed things.
I will have you outline that.
Okay. And then in this third one, we're down to the floor mat. This photograph shows a couple of items that the boy had told us about that we would probably find in the car. One of which is one of his sketch pads. The other is a bottle of beer that had been purchased earlier at Larry's Market. This shows also the reclining of the seat as the officers found it that night, the time of the stop. This photograph represents some of the clothing articles that we removed that he had told me about that we would probably find in the car. A pair of jeans, a shirt that he remembered, 2 other shirts, one of his sketch pads, and some of the photographs and items that we took from the car as well.
Detective Bean, you can go ahead and resume your seat. You say there was a bottle of beer in the car. Was there more than one bottle of beer in the car?
There was one bottle that was unopened that matched a bottle that had been purchased at Larry's Market, and one that was empty but did not match the second bottle on the receipt.
And how did you know that it had been purchased at Larry's Market, and when?
When the officers first contacted the boy, and he was wearing that coat, there were some receipts removed from that coat at the time that he was detained by the officers. And those receipts were dated on the 2nd of December, and the times were about 9:50 at night.
So that would have been sometime preceding the trip to the movie theater?
About 15 minutes before the movie started right next door, and 3 hours prior to them being stopped.
And when you spoke with the boy, did he indicate to you, you said that he said they had gone to Larry's Market. Did he indicate what it was exactly they had purchased there?
He just mentioned some food items and that there had been some beer purchased as well.
If we could clarify, Detective, the receipt for the beer, again, when was that dated?
Your Honor, I've seen the receipt. It should have been December, the 7th.
February
The
2nd.
February 2nd.
Correct.
Yeah.
So,
February 2nd, 1998 at, the first one is 9:49 p.m. The second one for 2 additional items is 9:54 p.m.
so Detective, I think you may have misspoke when you originally said December.
Correct.
And it was in
It is
actuality
February.
the evening preceding the detention of Ms. LeTourneau. Is that correct?
That's correct.
Okay. If you could continue, what were the items that you identified from the car that were of significance to you that you listed in your report? And you can refer to your report if you need to.
There's 2 other items here I'll present.
Your Honor, if I may interrupt, one of those, I believe, is a very sensitive photograph and such that it's not a compromising one, but it does show the young boy's face, and I would ask that the detective take care that that not be published and ask that the media not inadvertently publish it.
I don't believe it's been shown, Your Honor, to
Right,
this side, so,
It has
okay.
not yet.
I'll hand this one up. This is a standard photograph showing the young man and a young child. It's dated January 20th of 1998 with a date that is put on by the camera as the photograph's taken.
And who does that appear to be?
That is the boy that we contacted.
Okay, and do you know who the other individual is?
Not for certain, no.
It appears to be a small baby.
Yes, approximately 8, 9 months old.
And again, the date on that photograph?
January 20th, 1998. These items are a set of stickers that are made in a photo booth with this young man's picture in the center of these small stickers, which can then be peeled off and placed wherever one would like them. Those were located in the car as well.
Okay. You briefly outlined some of the items for the judge, or for the court, as you were showing Judge Lau the photographs, but if we could go back and talk about the contents of the car and what you found of significance in the car.
Okay. As we went through the car, we were looking for items that he had told us were in the car. Specifically, we located a pack of cigarettes that he said were in the front console, gave us the brand name, where they would be. I located a pager in the vehicle that we have determined, I think now, where that fits into this incident.
And that pager, was that later identified as belonging to a certain individual?
It was, yes.
And can you tell us about this pager that you found in the car?
This particular pager, we've identified them by the serial numbers through the paging company. This particular pager, the one that we have here, was a pager that Miss LeTourneau purchased in August of 1997. It was turned back to the paging company January 13th and was reissued to a friend of Miss LeTourneau's. It was given a new phone number at that time, and on January 29th it was given another new phone number, January 29th of 98, just a few days before this incident took place. It was given the second new phone number. That phone number that was issued on January 29th is the number that the boy gave me as the number that he called to page Miss LeTourneau. That number was not associated with that pager prior to her earlier incarceration. And that pager was then canceled or placed inactive the morning of February 3rd by the party that now owns it.
Now, this is actually the pager that you found in the car?
Yes.
And you said that the boy had also identified a pager that should be found in the car. Is that accurate?
That's correct.
And did you find that pager?
We did not find that pager, but we did find a receipt that would be part of the process of these pagers. In checking with the company that owns the pagers, we found a second pager that was issued or bought by Miss LeTourneau also in August of 1997. That pager had a number assigned to it in August and was then also turned in the middle of January of 1998. A new pager was then purchased by Miss LeTourneau, but was given the same pager number. So there were two physical pieces of equipment, but they retained the same number. And that second number is the pager number that the boy told me was his personal pager.
This is all kind of complicated. Detective, would it be accurate to say that the pager number that the boy gave you is the one that he contacted Ms. LeTourneau with was a pager that actually had only been just activated on January 29th of 1998? Is that accurate?
That phone number, yes.
So that phone number that he gave you, or that pager number that he gave you, is one that he had used in the past, had not previously been activated.
That's right.
And the pager number that he gave you as belonging to him was for a pager that was actually purchased by Ms. LeTourneau on January 14th. Is that accurate?
That's correct.
What are the other items that you found in the car of significance?
We recovered several articles of clothing that he indicated were his and that were in the car. Those are on the photographs that I've presented to the court.
You talked about a strong box.
Yes.
What was in the strong box?
It appeared to be some of Miss LeTourneau's personal papers. It was not locked. We opened it, and there was a significant amount of cash in the car.
And how much cash was there in the car?
There were 62 $100 bills.
So a total of $6,200?
Yes.
In addition, Detective, could you just describe basically for the court what this car looked like? What kind of items were in the car? Was there clothing?
Yes, there was quite a bit of clothing. There were men's briefs, still in packages, some socks. There was quite a few articles of baby clothing, infant wear, a small dress for a young baby girl. There were some items in the trunk that were baby books, story books, that type of thing, some small puzzles, articles like that. There were some large boxes that contained what to me looked like possibly some materials from potentially from Ms. LeTourneau's school classes, reports, looked like maybe some lesson outlines, that type of thing.
And you said you found beer bottles in the car?
There were 2 beer bottles, yes.
And these items, were they stacked up in the car that you could see them visibly from the outside of the car?
Yes, I think that shows on some of the photographs that the back seat particularly was pretty much full.
And was there
of
something in particular on the top of the items in the back seat that was resting on top?
Yes, there's a plastic gas can.
Okay, and was that full or empty?
It was empty.
Did you find any receipts that in this car?
Yes, we did.
And what kinds of receipts did you find?
There were several. We have, and now we seized several that we thought were particularly of interest to us. They were primarily from the Nordstrom company. They were charge slips that Ms. LeTourneau had signed, or where she had purchased several articles. They
Just
were
several articles?
well, a substantial amount of clothing.
And what type of clothing was it that you were able to identify as having been purchased?
I met with a representative from the store, and they provided me with what the codes were and what probably happened. There were purchases from the Northgate store, the Bellevue store, and the South Center store. From the period of January 20th up until the early evening of February the 2nd, there was about $850 worth of items purchased. These were all men's fashion, young men's sportswear, young men's shoes, and infant wear.
And infant wear?
Infant wear.
And did you also find receipts from other companies with respect to infant wear?
Yes, I did.
And these were all in a period of approximately the previous 2-week period, is that correct?
Approximately, yes.
In addition to that, Detective Bean, did you find any other identification that belonged to Ms. LeTourneau?
Yes, 2 items. In all of the property that was in the car, we located what appeared to be her personal day planner. Her driver's license was in one of the plastic covers inside of it, and we located her passport in the car.
Where did you locate her passport, Detective?
The passport was under the floor mat on the driver's side, up toward the firewall, sort of under the pedals of the car.
So it was hidden?
Oh, yes.
The photograph that you'd have identified as a photograph dated January 20th, a picture of the victim in this case with a small baby. Where did you find that?
That was in a folder. One would commonly get photographs back from a development company, which was that was on the passenger side of the car, and it down in the pile.
Which headed down in the pile? What do you mean?
Well, we had pulled some of the items out of the passenger's floor area before we saw that particular item.
So that was not a photograph resting on top?
No.
Did you also find other photographs in the car?
Yes, there were some that went along with that. Looked like they'd probably been taken on the same roll.
And was there also some undeveloped film in the car?
Yes, we found 3 rolls of undeveloped film and a Kodak FunSaver camera, which had been exposed but had not yet been developed.
And did you develop those rolls of film?
Yes, we did.
And what did you find?
The 3 rolls of film were pretty spotty. There was only a few images off of all the 3 rolls. 2 of them were images of Ms. LeTourneau. A couple of them were images of the boy. We developed what we could of those. Some of the images were taken at sunset from the market, the Pike Market here in Seattle, looking out toward Alki. And there were some pictures of some street lights and another waterfront area that we were not able to recognize where that was.
And you would say there were also pictures of Ms. LeTourneau and also pictures of the boy?
Yes.
And did the boy, or the photographs of the boy, consistent with how the boy looks today?
The ones from the 3 rolls of film were, yes. The film from the Funsaver camera where photographs taken appeared to me to be at the time of the birth of the baby.
And who was pictured in those photographs at the birth of the baby?
The child is obviously photographed. Miss LeTourneau appears to be in a hospital room or birthing room, that type of thing.
When you say the child, Detective, who do you mean?
It's a young infant.
Okay, so you say the infant was photographed, Ms. LeTourneau was photographed. Who else was photographed?
The boy was in the picture. And then there were 2 other women in the picture that I do not know.
So there were pictures of the boy holding the infant, is that accurate?
Yes.
Are you aware of whether there was a no contact order with Ms. LeTourneau in effect at the time?
I am not.
And in your viewing those photographs of what appear to be at the hospital, does the boy in those photographs look of a different age than the boy in the other undeveloped rolls of film?
He does to me. He appears to be younger.
At the hospital?
Yes.
Was there anything else that you found in the car, Detective, that you believe to be of particular evidentiary value?
I do. We located in the glove compartment of the car a letter. The letter is dated January 28th of 1998. It is from the boy's school. I believe it's from a vice principal. And it's a letter that is addressed to his mother.
And that was found where?
In the glove compartment of Miss LeTourneau's car.
And what did that letter indicate?
It was an advisory notice to his mother that the school was anticipating a change in his status as a student at the school.
He was being suspended, is that accurate?
Yes, he
And
was.
this was a letter notifying his mother on
Yes.
January 28th
It was dated January 28th.
and found in her car, in Ms. LeTourneau's car.
Yes.
Anything else that you found, Detective?
Don't believe so.
I have no further questions of Detective
Mr. Murphy, do you wish to inquire?
I have just a couple of questions. Detective, in the photos you've handed up to the judge, is there anything inconsistent with the way the car was packed and storage and old lessons plans and stuff? Anything inconsistent with someone that's sort of living out of their car or moving stuff from storage to someplace else in a haphazard way?
No.
Okay. And you indicated food. When I briefly glanced at those, there was like some snack food. It wasn't like someone was packing a box for a week-long camping trip, correct?
No, the food items that we found were consistent with what had been purchased at Larry's Market.
Okay. And you also indicated that the boy indicated to you that the early part of that evening when there was phone contact that Ms. LeTourneau had some items of the boys, some clothing items she was going to return?
Yeah, when he described to me what we might find in the car, he told me that he had some clothing were still in her possession, and she was going to return those to him.
And the shots of the boy at the hospital, is it your understanding that Ms. LeTourneau was a patient at the hospital? Was there indication of that in the photos?
The only indication I would draw from that is the fact that she was in the bed.
Okay, so there's no evidence to show that she went and contacted the boy. The boy was not the patient, correct?
That's correct.
One last thing. You indicated there were receipts for about $850 worth of purchases. Did you not also find evidence that contemporaneous with several of these purchases, there were also returns of things that had previously been purchased?
Yes, the total amount that had been charged over that period was just over $1,000. And then on some of her visits subsequently to stores, some of the items that were purchased were returned and others were added and then returned, and there was kind of a back and forth process there. But from what I could determine, the total of what was actually purchased was $850.
Thank you, Detective.
Nothing further, Your Honor.
Thank you, Detective. You may step down. Call your next witness.
And I know the court will want to hear from Mr. Gilkey regarding his recommendation to the court, but in terms of, he did interview Ms. LeTourneau, I believe. I would call him as a witness at this time. Good morning, Mr. Gilkey. Will you state your full name and spell your last name for the record?
David E. Gilkey, Gilkey.
And can you give us a business address and zip code for the clerk?
851 Poplar Place South, Seattle, 98144.
And what is your occupation, Mr. Gilkey?
I am a community corrections officer with the Washington State Department of Corrections.
And have you been assigned to the case of State of Washington versus Mary LeTourneau
Yes,
as
I
a
have.
community corrections officer?
Yes, I am.
And were you involved in interviewing Ms. LeTourneau subsequent to her detention on February 3rd?
Yes, I was.
Can you explain that to the court?
I received a call at approximately 5:20 in the morning on February 3rd. I was told that Ms. LeTourneau was found in the company of her initial victim. I spoke with a lieutenant from the Special Assault Unit with the Seattle Police Department. As she was on active supervision with our department, he asked what we wanted to do. I had spoken with my supervisor, and who had called me to let me know to call the lieutenant and discuss different scenarios and what we would do. After speaking with the lieutenant, it was decided that I would go down to the King County Jail and place a detainer on Ms. LeTourneau.
And did you speak with her?
Yes, I did.
And what did she tell you?
At that time, she told me that she had been to a late movie the previous night. She stated that prior to going to the movie, she'd done some shopping. After the movie, she had returned to her home. While she was gathering her belongings from the shopping and whatnot, and as she was getting ready to go in the home, the boy stepped out of some bushes and high growth around the residence she was staying at, and got in her car. She stated that subsequent to that, they started to kind of argue. She was telling him that she couldn't have contact with him. He was putting her in jeopardy with her supervision, and she was in the car for 10 to 25 minutes when the police arrived. I asked her further about that, and on further questioning, she stated that they were in the car that long because she had been told by the boy that he had run away from home, and she wanted to make sure that he got somewhere safe so that he could return home.
Did you have any further discussions with her that day?
Not that day, no.
You subsequently talked to her again?
Yes, I did.
And when was that?
February 4th.
The next day?
Yes.
Okay. And did you speak to her again about the events of the evening?
We mostly discussed things, the possessions that were found in the car, and how those related to her story.
Okay. Had you been involved in the actual search of the car?
Yes, I was.
Okay. And so what did she tell you about the car?
We questioned her about a number of the articles found in the car. As for the clothes that the boy had told Seattle police officers were his and were in the car, again, she stated that he had run away from home and he had those in his possession when he got into the car. I questioned her about the cash that we found. She stated that $3,200 was earmarked for a dermatology person that she was going to. I'm not clear if it was treatments or medication or whatnot. She also said $3,000 was earmarked to her, or to pay for her divorce attorney. She stated that the $6,200 were the remains of a retirement account that she had previously cashed out from her teaching job. We asked about the pagers. One of the pagers, she said, had been broken for 2 to 3 weeks and had not worked. Another pager, she said that she had simply borrowed from a friend and they were kind of both using it, that her friend was letting her give that number out.
The one that was broken, do you know anything further about that, whether that was the one that she said was broken? Do you know whether that was the one that the boy had identified as his?
I believe it was. When questioned about the clothing, the articles of clothing that the boy had not identified previously, she stated that they were hers. She simply enjoyed wearing oversized men's clothing. They were more comfortable, and that's why those clothes were in the car. There was also a tie in a Nordstrom's box that was apparently brand new, wrapped in tissue. She stated that was a gift for her father. A brand new pair of shoes apparently were a gift for her son in Alaska.
Did you also note that in the car there was men's underwear that was still in its container?
Yes, I did, and I did not ask her specifically about that. Concerning the other possessions in the car, the boxes, all the papers, that kind of thing, Ms. LeTourneau stated that she was moving out of her home that she had lived in prior to going to jail, and that they were just possessions from that home that were in her car because she had been moving over the past few days. As for the beer, Ms. LeTourneau stated that the bottle of beer that was unopened simply was in the basement of her home that she had been moving out, and that she had put it in the car with the rest of her possessions.
But was this the same brand of beer also that was reflected on the Larry's Market receipt?
Yes, it was.
Anything else that she discussed with you, Mr. Gilkey?
We did discuss some of the photographs that we had found in the car, not the exposed, undeveloped film, but the actual photographs, and she stated that they were simply old photographs that had been in her belongings and had been, again, in with her things as she was moving out of her old house.
Now, you say she was moving out of her old house. Was there a new residence where Ms. LeTourneau was living?
Yeah, she was living with a friend.
And was that the same residence? How long had she been living there? At the new residence?
I assume since she got out of jail, I assumed this case 1 or 2 days after her release, because that residence is in my catchment area, so I assume that she actually released from jail to that residence.
Okay, and did you have an opportunity to look at that residence?
Yes, I did.
And did you identify a room or some portion of the house where Ms. LeTourneau was actually staying?
The owner of the residence showed me Ms. LeTourneau's room and pointed out they both had possessions in the room The owner of the residence pointed out what were her possessions and what were not.
And what was identified as Ms. LeTourneau's possessions of the room that she was living in?
A few articles of clothing, a couple bags of clothing, some toiletries, some what appeared to be, I didn't look at it closely, but some type of holistic diet supplement or something like that. And a couple of small square boxes of Christmas decorations, ornaments, that kind of thing.
Did this appear to be a room to you that Ms. LeTourneau was actually living in?
It didn't really appear to me to be a room that anybody was living in. It was fairly void of any thing that I would think people would keep in their room if they were staying there.
I know, Mr. Gilkey, that the court will want to hear your recommendations, but for now, I think that I have no further questions.
Mr. Gerke?
I have just a couple, Your Honor. Mr. Gilkey, were you able to determine the closeness of the incident with Ms. LeTourneau's residence that you examined later?
I spoke with the owner of the house who pretty much witnessed the stop, who informed me that it happened in front of the property.
So it was like right at the residence?
That's my understanding.
Okay. And was this the first time you were at the residence?
Yes, it was.
Okay. Do you have somewhat of a recollection of the neighborhood?
Yes.
Okay. Residential area?
Yes.
It's not a dead end?
No.
And very close, like a half a block or a block from a major arterial?
It's close, yeah.
Okay. Very open area?
As open as most residential neighborhoods.
Okay. And you were assigned this a couple of days after her release?
Yes, I was.
And if memory serves me right, January 2nd was her release date. That would have been a Friday, so it would have been, say, Monday or Tuesday, assuming you work a 5-day week.
My understanding is I assumed supervision of this case on January 7th.
Okay. And part of your duties of supervision included making sure that Mary was following the conditions, correct?
Correct.
Okay. And you had been provided the lengthy list of conditions?
Yes, I was.
Okay. And until you got that phone call in the early morning hours of February 3rd, you had not filed any report indicating that she was violating any of those conditions, correct?
No, I had not.
Okay. And did you go over those conditions with her shortly after assuming the case?
Those conditions were gone over with her twice by the officer who completed the intake, and then once I met with her also.
Okay. So there's no doubt in your mind she understood the conditions?
None whatsoever.
Okay. Now, did you ever talk to her about what she should do if the boy contacted her?
No, I did not.
No further questions.
Ms. Johnson? Sir, you may step down.
Your Honor, this court extended the defendant a privilege that she has demonstrated that she does not deserve. This woman who stood up before the court and demurely proclaimed to this court at sentencing, "Help me, help us all," clearly has no intention of helping herself or helping any of the individuals she has harmed. Once again, she blames the victim for her own conduct. Other than a few words at sentencing, she has never shown any commitment at all to comply with the treatment process, and instead has used it for her own manipulation. It's nearly universally acknowledged, even by the treatment providers that the defense presented to the court, that she doesn't believe she needs treatment because she doesn't believe she did anything wrong. And she continues to display that same conduct. Now, only 1 month from her release from confinement, we find the report from Dr. Copeland, who indicates that every session that she has had since her release from confinement has been contentious, that she has questioned his authority, questioned his treatment. We see the letter from even Dr. McGuire that arrived yesterday that indicated she wanted to mold the terms of her medical treatment with Dr. McGuire, that she wanted to pick and choose the particular medication she was on. She refused to sign the conditions of treatment with Dr. Copeland, saying that she didn't want to abide by the alcohol condition, questioned his authority and what his role was in the process. She refused to sign the condition that allowed Dr. Copeland to speak with the other treatment providers that the court had directed that she be under supervision with, Dr. McGuire and Dr. Conti. And then she commits what is really the most egregious violation that she can commit in terms of the directives of the judgment and sentence by having contact with her victim. This is consistent with the track record that she has shown in the past. Before she even pled guilty, she was out of compliance with the treatment providers that she had offered to the court. She either didn't show up for her sessions or was late for her sessions. She drank alcohol, all out of compliance even before time of plea. After plea and pending sentencing, she was still in violation. She didn't believe that she was under any treatment conditions because she had decided she didn't want to be with that treatment provider anymore. And she was having contact with the media, which was in direct violation of the treatment provider she had been seeing. She forum shopped throughout the process for different treatment providers when they did not provide her with what she wanted. The evidence presented in court today suggests to the state a number of things. First of all, that there was more than one contact with the victim. Ms. LeTourneau simply is not credible when she says that this was the first time that she had met with the victim. She is not credible. She lied to Officer Harris when she first approached him and said that everything was fine in the car, no one was in the car with her, and that her name was Terry Schmitz, giving both a false name and a false date of birth to Officer Harris. Later indicating in the same conversation that, oh, indeed, her real name was Mary LeTourneau when she was confronted with the fact that he knew who she was, that she had, gone to a movie by herself and that he had come out of the bushes and been waiting for her. We know that she's not credible. We have heard what the victim told Detective Bean about what really transpired that evening, and the items from the car corroborate that. We have the ticket stub from the movie theater in the pocket of the jacket he was wearing that he identified as Ms. LeTourneau's, and we also have the receipt from Larry's Market, which also indicates that beer was purchased that evening. We know there was more than one contact by virtue of the pagers that have been identified, and I know that it's complicated with all the numbers that were recited or the discussion about the pagers, but essentially what we have is a pager number that the victim identifies as belonging to him. He tells Detective Bean that this is his pager number. Detective Bean then finds a receipt in the car which indicates that that pager, that the victim is identified as his, was actually a pager purchased by Ms. LeTourneau on January 14th. The other pager number that he identifies as the number that he called because he had suddenly remembered the number he had paged her in the past, that number, we learn, was only activated on January 29th of 1998. What also suggests that there was more than one contact is the amount of men's clothing in this car. Starting on January 20th, purchases at Nordstrom, men's furnishings, men's sportswear, men's shoes. Photographs in the car indicate that there's been more than one contact. Undeveloped rolls of film with photos that look consistent with the boy at the age he is now. And specifically, the photograph dated January 20th, 1998, which reflects a picture of the boy and an infant child. Also indicating that there's more than one contact is the letter in the glove box written to the boy's mother, dated January 28, 1998. It is not reasonable to believe that all of these items suddenly came into the car that night. Furthermore, Your Honor, it is certainly arguable that it appeared as though Ms. LeTourneau was ready to leave the jurisdiction. Her belongings were all in her car. They were not at the residence that she was to have been living at for a month. There was $6,200 in a car. Is it reasonable to believe that someone would park a car in virtually the middle of Seattle with packages that one can see from the back of the car and leave it with $6,200 in cash in the car? The only reason that you would be in the car or leave that kind of money in the car is if you were going to be in that car. We further find a passport that is virtually hidden underneath the floor mat and up by the gas pedal, and an empty gas can at the top of the back of the car. This is all evidence that certainly would lend someone to believe that they may be fleeing. And it is not too far a stretch to think that Ms. LeTourneau was going to take the boy and the baby by virtue of the fact that there were many baby clothes and baby purchases since the middle of January, and that she would flee with both the victim and the baby. Your Honor, Dr. Wheeler identified at the time of sentencing one of the primary, most significant risks that Ms. LeTourneau posed in the community was to her victim, and she has validated that concern. In addition to that, she very well may be a risk to the baby she bore with the victim, and she may be a flight risk. As she abused the trust that she was given as a school teacher and as an adult, she has now abused the trust of the court. This court has no option today but to immediately revoke the 89-month suspended sentence. She should be sent to prison. Then at least her victim can grow, the people she has harmed can grow, and be safe from any further manipulation and control that she has on them. We respectfully ask that this court revoke Ms. LeTourneau's suspended sentence.
Mr. Gilkey, may I hear from you?
Your Honor, there are a number of things that concern me about this case and what's transpired over the past few days. First of all, when Ms. LeTourneau was contacted by Officer Harris, her actions to me don't indicate somebody who is concerned about getting a boy back home to his parents, or somebody who is concerned for their own personal safety, as she told me. Once Officer Harris had contact with Ms. LeTourneau, it seems to me that she would have immediately told the officer what was going on. Somebody was in her car that she was either threatened by or needed to get home. Instead of denying anybody else was in the car, giving a false name. Ms. LeTourneau, another thing that bothers me is that Ms. LeTourneau, although only in treatment with Dr. Copeland for approximately a month, through the evaluation process, had been involved in the treatment process for some time. She was well aware of the conditions of her supervision and of her treatment program. She continued, through her own admission, to have contact with the boy anywhere from 10 to 25 minutes. It would appear through police reports and through other statements that she had had contact with him for a much longer period of time that evening. She also was aware through her treatment program that she was not to consume alcohol. At this point, I have no indication that she did consume alcohol. However, it's obvious that she purchased some that evening. As defense counsel stated earlier today, Dr. Copeland stated that it would take a while for Ms. LeTourneau to settle down. I think after sentencing, it's common for offenders in that type of treatment program to have kind of a honeymoon period where they kind of test the limits of their treatment program, of their community supervision. Usually these are fairly minor infractions. In this case, they're not. As the prosecutor has mentioned, in my opinion, this is the most serious violation that Ms. LeTourneau could have committed. And because of that contact with her original victim, she's now been terminated from treatment. In my opinion, when the court gave Ms. LeTourneau her SOSA, the court at that point was giving her second chance. I think that once this type of offense has been committed, it's a privilege to remain in the community, and the people that are given that privilege need to strictly adhere to the court's orders and to the treatment process. I think Ms. LeTourneau made a conscious decision not to follow her conditions of supervision, not to invest herself in the treatment process, and because of that, I would recommend to the court that her SOSA be revoked and she be sent to prison.
Thank you. Mr. Gerke?
Thank you, Your Honor, for an opportunity to speak. I would formally renew my motion for a continuance just because of this flood of information. I think it would be more appropriate to take a better look, and we've discussed that earlier, and I understand the court's concerned to go forward, but I would like to make a record on that. It's difficult for me to be here, Your Honor. I feel like I have let you down, and I know that I have let Mary down. I'm a friend of Mary's, and I'm an advocate of Mary's because of my profession, my friendship, and my loyalty. By default, I'm an advocate for the many, many children that are directly involved in this case. And I will speak briefly about them in a moment. And I would guess that it's difficult for you as a judge. I know it's difficult for the state to see this happen and to come forward and to ask somebody to be locked up for 7.5 years. You made the right decision November 14th, Your Honor. It was a tough decision. But you, perhaps more than Ms. Johnson or myself, had the vast information, the details, the written material that others were not privy to. We all recognized, and still do, that Mary is sick and that she needs help. And as I thanked you November 14th, I will renew those thanks for giving Mary a chance to get help. Those that have criticized you we're not privy to that material. And perhaps we're just cold-hearted. To criticize without the facts shows either ignorance or disrespect for our judicial process. It shows a disregard for our country's foundations. In the old days, the foundation was justice for all under the law. Nowadays, the politicians just want law because they can't control justice. They want to do away with the judicial branch. Judges nowadays have a lack of discretion. The legislature is trying to micromanage our judicial system. Your Honor, they have taken a lot of possible and better alternatives than the ones you have before you today away from you. And I'm sorry for that. I cynically suggest that perhaps in another decade or two we'll have a computer in the police cars and you'll punch up the crime and you'll get the sentence right there, and we won't need lawyers or even courtrooms because the legislature are going to continue pandering to the public. Justice is not black and white, Your Honor. Justice is not more and more prisons. I'm sad as an attorney at the incarceration rate in our country. I apologize to the world that we still execute people in our country. The studies that have been done in our state, Your Honor, show that the recidivism rate from someone that completes a treatment program is significantly less than someone that goes to prison and attempts to participate in a treatment program there. And lest anyone think that the treatment program in the prisons is anywhere near competent, one need only look at some of the federal judges' opinions on the treatment programs in our state. Voters should question and challenge pandering politicians that are wasting our tax dollars and our time under the guise of law and order. I ask you for justice today, and I admit that justice is not easy. And as tough as my job is today, Your Honor, I'd rather have my job than your job today. Recall the image of justice. The blindfolded woman with the scales in one hand and the sword in the other hand, because justice sometimes is harsh. But I think that harshness is tempered by the vision that it is a woman, someone with a heart, that's administering justice. I received a letter from my pastor almost a year ago that I'd like to share. David, I've been reading the paper. Our thoughts and prayers are with you as you handle the trauma of the LeTourneau case. May God grant you the wisdom of Solomon and the heart of Jesus. What should happen to Mary LeTourneau today? I'd like to read a couple comments from Dr. Conti's report. He points out that he was the court-appointed psychotherapist for Ms. LeTourneau, and he indicates he's seen her about 3 times a week since her release. He points out her concern when she received the emergency telephone call from her son, who was suicidal. He points out that relapse is common in all forms of psychotherapy. Relapses in sexual offender therapies is expected, and this is why offenders are constantly polygraphed. He points out that she had worked out a successful solution with Dr. Copeland regarding sharing information between himself and Dr. Copeland. He points out, Your Honor, that in his opinion, the treatment team, and I put myself on that and accept some of the blame, failed Mary. In particular, it was an error not to work with Ms. LeTourneau about how she would behave if the victim contacted her. It was the doctor's opinion that both Ms. LeTourneau and the victim share a delusional system. It was error, in his opinion, to focus therapy time on logistics of which proper form she would sign or not sign, or how to deal with reunification with her children down the road, and not to deal with these current important issues. He points out that the police report, in his mind, confirmed that we have 2 adolescent individuals. And while she is of an adult age, emotionally she functions as an adolescent. And he also points out, Your Honor, that it is clear that Ms. LeTourneau is surrounded by a group of individuals who in various ways have supported her delusions about the victim and the criminal justice system. And those people know who they are and share the blame. Your Honor, I will not read into the record the 2 paragraphs that are quite lengthy with very specific details that Dr. Conti recommends as the appropriate sanction. The court has read those, and I endorse those. Basically, he is urging that Ms. LeTourneau be locked up for each of those violations, and I submit if 120 days isn't long enough, the court on its own motion could find a 3rd violation, and that would be the alcohol one, and lock her up for 180 days. And Dr. Conti recommends that, and I endorse it, and then get her on treatment with a treatment team that now recognizes its failures and lapses, and allow us to come back in 120 or 180 days and see at that time if we can find a person that is recognized and accepted that feels they can treat Ms. LeTourneau. And Dr. Conti represented 2 names that he would be comfortable with, and as the court may know, those are names that the defense does not normally jump to when we have a choice on treatment programs, but Your Honor, they are both very, very well respected by the state, the court, and in reality by the defense bar. I can represent to the court that one of those individuals has indicated a willingness to evaluate and took pains. It's the same individual that we presented to the court shortly before sentencing, took pains to say that the willingness to evaluate by no means should be interpreted as a willingness to treat or to not treat. Dr. Conti, who actually provided therapy to me just in a brief hello and goodbye at the jail when I ran into him up there, shares with the court his understanding that everybody involved is no doubt angry and have feelings of betrayal at this relapse. And that's an accurate conclusion, I dare say. It's important to note, Your Honor, and this is Dr. Conti's words, that this relapse does not mean that the court's original sentence was incorrect. And again, I submit it was not, and it should stay in effect. Mary does still need treatment, and Dr. Conti points out that locking her up is not going to cure her and in fact could cause the delusional beliefs of both her and the boy to continue to grow. Your Honor, when I play ball with my little boy, my little 3-year-old, we play ball in the backyard so that he does not run inadvertently into the street, because he's too young to be held responsible if something should happen. A driver that would accidentally hit him certainly could not be held responsible because it was beyond their control. A developmentally disabled person cannot be held responsible for some of their actions. Every expert at sentencing told you about Mary's condition and what it causes her to do. She needs to be in a treatment program and underway, and Dr. Conti's suggestions allow that to happen. The wisdom of Solomon and the heart of Jesus. If you recall to your Bible days, Solomon had to worry about one child. Should he split it in half and give it to both or not? You, Your Honor, have 3 sets of children that you have to deal with. And again, I do not envy you today. We have a young boy who might be delusional, who you were told about at sentencing was perhaps suicidal, who felt responsible back then, and certainly feels responsible for today's outcome. His life's been turned upside down. He's been abducted by TV crews. He's been subjected to ridicule. He's been kicked out of school. And the paradox is that to protect him, we're going to lock up Mary, which will make him more depressed, cause more counseling, and perhaps more dire consequences. Society does not need to be protected from Mary LeTourneau. Even Dr. Wheeler told us that. My children, your children, they do not need to be protected from Mary LeTourneau. She's fixated on one person. Your Honor, the person that really needs to be protected from Mary LeTourneau is Mary LeTourneau. We need to protect her from herself, and locking her up is not going to do that. She's already on suicide watch, Your Honor. Justice can cut both ways. 9-month-old little Audrey, you have a picture of her up there, Your Honor. I have held little Audrey. I saw Audrey on the day she smiled, her first smile, back in August. I've seen her first tooth. It broke my heart to see Audrey come into the jail back when Mary was allowed visitation with her, and start to smile and sort of kick like a little infant does, because she was going to see her mother. And we were getting close to reunification. Audrey will never have a mother. She's got a loving grandmother, but we have to talk about that. We have 4 other children that have a heavy, heavy concern on today's position. And while Steve and Kelly are doing their best, Mom is still Mom. The firstborn son, 13 years old. Dr. Conti points out the suicidal implications there. His adjustment problems, the realization that Mom might miss his graduation, his first prom. your firstborn, you don't love your other children less, but you love your firstborn differently. And there's a special bond. Mary's going to lose all of that. The oldest daughter, that special mother-daughter bond. I have 5 sisters. I'm well aware of the bond between the oldest daughter and my family and my mother. That 10-year-old girl, her first date, her graduation, whatever happens in the next 7.5 years. That's part of justice, and sometimes justice is harsh, and that's justice. And sometimes justice requires mercy and opportunity. I had the privilege of talking to Steve LeTourneau yesterday. He said the children were getting excited. They knew that reunification and perhaps visitation was starting to be talked about and details worked out for months down the road. And as Dr. Conti pointed out, perhaps that should not even been started yet. They should have just focused on Mary right now and her treatment. Last April or early May, the children were pulled out of school on short notice because there wasn't proper supervision. They were sent away all in one day. A good friend of mine lived next door to those children and described the sobbing, the wailing, the heart-racking, utter despair of the oldest daughter as the only stability she had left, and that was her best friend from next door, was being yanked from her. And they have held on to some semblance of stability, knowing that 6 months, in a year, they could reunite with Mom. The 2 youngest children of Mary's from Steve are 6 and 3, the same ages as my children. They played with my children. I can't imagine telling my children that Mom's going to be gone for 7.5 years. To a 3-year-old, that's forever. Your Honor, every Friday in King County we have sentencings. They're always traumatic and they're always serious. There's always the ripple effect. And how many times has a drug dealer come before you? Maybe with me even. And said, Your Honor, if you send this man or this woman to prison, his wife's going to be alone, the children are going to miss their dad, or someone that's assaulted. And the court looks him in the eye and says, how sorry you are. And one can see the pain on your face, because it is painful. And you tell the defendant, you're responsible for your actions. And justice is harsh sometimes, because you have to be responsible for your actions. Your Honor, every expert that's been before you has said Mary cannot help her actions. Every expert has said she needs some help, she needs extra supervision. I ask you to give her that help and that extra supervision. Your Honor, sometimes I've disagreed with your decisions in the past. I've always respected them. Being a judge, dispensing justice, is never easy. And anybody that thinks it's a black and white issue and that it's so easy and simple has never sat in your seat, has never appeared as counsel with heavy burdens and conflicting positions. Thank you once again for your concern, your consideration, and your courtesies. May God grant you the wisdom of Solomon and the heart of Jesus. Thank you.
Ms. LeTourneau, do you wish to be heard? We'll take a short recess at this time. The sex offender alternative is the only sentencing option under the Sentencing Reform Act, which allows a judge to suspend a sentence and impose treatment for eligible first-time offenders. The legislature recognized that if the opportunity for treatment is given, the consequences for failing to comply must be severe. Less than 3 months ago, you were given the opportunity, Ms. LeTourneau, for treatment. Within weeks of your release from jail, you purposely violated the conditions of your sentence. These violations are extraordinarily egregious and profoundly disturbing. This case is not about a flawed system. It is about an opportunity that you foolishly squandered. The suspended sentence is hereby revoked, and the original sentence that I imposed not long ago of 89 months is imposed. Ms. Johnson?
Is there an order, Your Honor?
I've signed the order.
Thank you, Your Honor.
Thank you, Your Honor.
Ladies and gentlemen, be seated again, please, until the defendant is left.
Where will you go?